Now, for me to talk about the Supreme Court in 29 minutes and 8 seconds is a little bit like, there's a famous story of the first century Rabbi Hillel the Elder, who was known for being very wordy, and he would never give you a minute if he could keep you for half a day. And some of his students at one time asked him, Rabbi, please, could you summarize the law and the prophets while standing on one foot? And so, not to be outdone, he stood on one foot and he said, that which is hateful to you, don't do to other people. The rest is details. Go home and study. Now, if that sounds vaguely familiar, like the Golden Rule, it might surprise you to know that Hillel the Elder was half a generation before Jesus. And in those Bible stories where Jesus as a child is missing and his parents find him with the rabbis, it's probably Hillel. That's for Sunday school, though, not for now. Now, speaking so much about the court in the last few weeks has really put me in mind of my own college days. When I was in undergraduate school, I loved history. And when I was at UTA, I had a Western history course from Elliot West, who went on to chairmanship of the history department at Arkansas, won the Parkman Prize, presidency of the Western History Association. And so I really, really wanted to study history. And then my family said, well, yes, dear, that's lovely, but you really must have something to fall back on. So I came down to Austin to go to law school. And now, in law school here at that time, the most formative moment for me in law school was I had the legendary Stanley Johansson for property, and I got called on the third day in property class. I'm sure we've all seen the paper chase. We know the terror of fresh laws being called on. And he asked me to recite this case, and I got out about half a sentence, and he turned his back on me and he said, Smith, why is he wrong? Well, you can imagine, I mean, fighting tears and, humiliated my beginning of law school. Well, the discussion bounced around the room for about 20 minutes on the topic of how I'm an idiot. And the bell rang, and it was time to pull things together, and he said, well, where does this leave us? Haley was right all along. I thought, you son of a... So law school was pretty much downhill from there. But who knew 30 years later that this would be happening? Oh, by the way, I also had the legendary Russell Weintraub for contracts. And after my second year in law school, I got a phone call from my editor at Doubleday. And he said, how's law school? I said, well, it's very challenging. He said, have you had contracts yet? I said, yes, it was wonderful. He said, well, remember you signed one with us to deliver a book last year. So I had to take a leave of absence, finished their book, did a couple more, and I thought, this is a good life, not knowing, that the publishing industry would collapse many years later. But who knew that many years later, Bill Pugsley would call me at a TSHA meeting and say, we're interested in finishing out a history of the Supreme Court. Are you available? So I got to use my history background. I got to use what I learned of the law, and I had more fun doing this book than that legendary Barrel of Monkeys. Now, the first book about the Supreme Court, 1917, Harbert Davenport. Now, the Davenport book is a product of its time. It's primarily biographies of the justices and very briefs of their important cases. And all those judges at that time were wise and kind and loving husbands and fathers, pillars of their community, every one of them, except for that period of Reconstruction. And those guys were venal and corrupt and evil and, loathsome to look at. And, the whole post-Confederacy thing. But that was the extent of the book. The whole business of Texas' incredibly imaginative approach to jurisprudence and things that we invented for ourselves. Not a word about that. So when I wrote this book, you've heard of a case of first impression? A lot of this is a history, really, of first impression. And it begins, actually, at the beginning with pleadings. Now, the Spanish had been trying to get their people for many, many years to come up to Texas and settle, and they wouldn't do it because it's hundreds of miles from home, and the Indians would kill you, and they wouldn't do it. So they went to one of their other colonies, the Canary Islands off the west coast of Africa, and told these people, hey, with this vast empire over there, you sell out here, move over there, and you will all have the status and rank of hidalgos. You will be nobles over there. So they rounded up several Canary Islanders, and they got to San Antonio in 1731, discovered that it's the frontier. Everybody has to work. Well, the first thing they started doing was suing each other because they're very contentious people. Well, there's no precedent. There's no way to get into court. So what they did, they turned to the notario of the villa, whose name was Francisco de Arocha. The legend was that he had the most elegant handwriting. Although there's been some very detailed research done, and he was not the only guy who had a legible hand. Anyway, he had nothing to guide him, and so he said, well, how do we start somebody in court? And he invented the whole thing. Who are you? What happened to you? Who did it to you? What do you want us to do about it? And that was how you got into court in New Spain. And to this day, Texas has always had these simplified pleadings that ought to be the envy of the rest of the country. Now, after the Revolution, we get our independence. Here comes all these American lawyers down here who have honed their skills in the pleadings of the common law. There's like 8 different steps you have to go through. And these guys were masters of how to win your case before you ever get to the merits. Your 5th step of pleading was defective, therefore I win. And Chief Justice Hemphill, of whom you've heard enough, I don't have to tell you more about Judge Hemphill, he was the one who said, no, we're going to do what works for us. And so to this day, we've always had the simplified process of pleadings. Other things under Spanish law that found their way into Texas jurisprudence, a lot of it goes back to Queen Isabella of Castile. And I don't know if, how much you know about her. As a young princess, her father tried to marry her off to a couple of other people for his political advantage. They wound up dead. Isabella herself was the one who picked Ferdinand of Aragon to be her husband. That was her doing. She squeezed a prenup out of him. And in fact, during their reign, she did not take a crown matrimonial. In fact, it was their motto, tanto monte, monte tanto, same power, same station, same state. And all their decrees are signed by both of them. And this is a large part of the origin of this elevated status of women in Spanish law. And that's the first thing you have to understand about Texas jurisprudence is how different it was in some of its aspect from what the United States inherited from England. With women, women in New Spain could own property. They could go into business. They left a marriage with community property. In the common law and in the United States, women pretty much belonged to their husbands. Sam Houston used to take speaking tours around the Ohio Valley, just touting how much better women had it in Texas. With debtor and creditor, there was a decree from 1498, Ferdinand and Isabella. Well, if you owe money, you need to pay it. But they can't come take everything you have. They have to leave you the means to continue making your living. Well, in England, they had debtor's prison. And in the United States, they inherited debtor's prisons. With water law, Spain, semi-arid, when you bought property, the water that flowed through it or around it, you didn't get that water unless it was specifically conveyed. England's very rainy. Nobody even thought about water. As I don't know if anybody has talked about in the 20th century how the water law went astray and then was brought back. We'll get into that in just a few ways. So after our revolution, decisions had to be made about whose law are we going to follow. And one of the things I love about Justice Hemphill is that when the Texas Congress passed the statute in 1840 saying we're going to adopt the common law as our rule of decision, with just a couple of exceptions, Hemphill pretty much said, well, isn't that stupid? And so when people came to take your homestead, we had this homestead exemption that American lawyers were always, these lawyers who had gained their law degrees in the United States were always looking to chisel away at, and there's case after case where Hemphill said, no, this is absolutely ironclad. Homesteads are going to be exempt from seizure. Now, Texas, and a lot of people don't really emphasize this, Texas is where the Old South met the Old West. It's the only place on the continent where you had slave-owning cotton planters looking over their shoulder against Indian attacks. The Old South met the Old West, and it gave a whole different complexion to our jurisprudence here. One case that I really like, Jones v. State. Early in our statehood, there was a murderer, this is back when the Supreme Court had criminal jurisdiction, appealed his conviction purely on the grounds of, well, I had more witnesses than the prosecution. And there's this elegantly worded opinion written by Admiral Lipscomb, who's another one of my favorite justices, saying, well, that's not really the way it's going to work in Texas. It's not going to matter how many witnesses you have. It's what did they say and how credible were they. He did overturn it, however. He said it was a reversible error for the bailiff to have been giving whiskey to the jury while they were deliberating. very unique things they had. There were lots of land cases. Of course, now there's no part of the continent more than Texas. We were giving land away to soldiers of the Republic for their service. We were attracting settlers with land. And so vast tracts of land were always the target of somebody else. One of the more interesting cases from back then, Hall v. Phelps, Dallam 435. One of the big landowners in Matagorda County, Warren D.C. Hall, got his league in a labor, which was about 4,400 acres of land. But his neighbor, whose name was Phelps, had 1,000 acres that he thought was particularly attractive. So he waited and bided his time, and eventually the Phelps family left for the United States to visit their children. And when they came back, they found that their slaves were gone, the overseer was gone, and Hall and his riders were in charge of their ranch house, and he gave Phelps a paper. Said, you want your land back, you have to give us this 1,000 acres. And then the consideration for that is you get the rest of your league back. And so Phelps, not having any other thing to do, signed it. And then we had the Revolution. Now this is before the Revolution. 7 years later, when things had settled down, he sued to get that 1,000 acres back. And Hall, who's a very inventive lawyer, came up with all kinds of ways why he should keep the 1,000 acres. Well, keeping the rest of his land was valid consideration. And the Supreme Court, it's one of the more annoyed decisions that you will ever see from a Supreme Court, said that Hall had reigned supreme over this seized land like a Norman baron. That's not going to hold up. They cited an old civil law maxim that what the law constrains you not to do, and you do it, you can't take consideration for giving it back. Hall said, well, it's been 7 years. He should have filed his lawsuit in a timely manner. And the Supreme Court said, well, we had a revolution. No, we're going to hear the case. So that's the first instance where the Supreme Court began to make allowances for this disruptive frontier condition that everybody worked in. See, but a lot of people don't realize these early justices cut down by yellow fever. One was, in fact, it was Hemphill, was caught up in the council house fight in San Antonio, stabbing Indians. One, Justice Anderson Hutchinson, was kidnapped by an invading American army and taken off to a dungeon in Mexico. Life is not certain back then. And then, as now, many people became a judge and realized how little money you make, and they went back to private practice to earn more money. Nothing new there. Now, here's another aspect of that unsettled frontier, is that we wouldn't have any of these cases from the Republic if it hadn't been for this eager beaver. His name was James Wilmer Dallam, D-A-L-L-A-M. He was from Maryland. He had read for the law in the United States under Reverdy Johnson, who later became an attorney general. Came to Texas to make his fortune, moved to Matagorda, nothing really going on there, so he moved inland to the capital of the Republic, which at that moment, it moved around, was at Washington on the Brazos. And he realized that this several years, 8 years of Supreme Court decisions had never been collated and recorded anywhere, so he made that his business. And when you think about the rivers would rise and mail would be lost, and a lot of the pleadings at the time the Supreme Court got them were a mess. In fact, the early decisions, a lot of the early pleadings and practice elements of these decisions were, well, we have to make allowances for these people who don't really know the law because they're out in the middle of nowhere. By the way, one of our early Supreme Court justices, Robert McAlpin Williamson, Three-Legged Willie, revolutionary figure, got his nickname, leg bent back at the knee, probably by polio in his teens, so he walked on a prosthetic leg from the knee down, so his nickname was Three-Legged Willie, which did not for a moment prevent him from being one of the most celebrated dancers in the Republic. He was just kind of off balance when he would twirl. He's the guy who set up the first court. Now, under the Republic, you had the Chief Justice, and they were called associate judges at that time. They weren't justices. But each one had a district, and each of these district judges, when they would meet en banc, were the Supreme Court. Well, he went to East Texas. It was during the height of the regulator-moderator feud. And so he set up court, and one of the feudists, the regulator-moderator war, was the biggest, bloodiest, multi-year feud in Texas history. One of the feudists came up to the bench and thumped his Bowie knife into the bench and said, "This, sir, is the law of Shelby County." And not to be outdone, Judge Williamson leaned back, cocked his pistol, and said, "Well, this, sir, is the Constitution that overrules your law. Sit down." Totally fearless. And for a Texas historian to have figures like this to sink his teeth into, oh my goodness, was it fun. Now, Dallam himself, he took this project on himself to collate all these decisions, went back to the United States, and since nobody was interested in publishing it, borrowed some money from his dad, who got it published, and then he came back to Texas with these bound volumes, Dallam's Decisions, big, rare book. Does anybody own a copy of Dallam's? Yep, there's one, two, and there's one at the Supreme Court Library, there's three. Fascinating, fascinating stuff. And they sold like hotcakes. So he was a social somebody. He was making money. He married the daughter of the Texas Secretary of the Navy. Got offered a good job down on the coast when he wanted to go to New Orleans and settle his affairs. So he went to New Orleans, got yellow fever, and died. Because that is life back then. Nothing is certain. Now, one other aspect about these Republic and early Texas decisions, I bet you didn't know, is that slavery and the rights of free blacks was a large subject to the Texas Supreme Court at that time. And Texas, I'll bet you didn't know, was by far the most liberal state in the Union, and coming out of the Republic, they became the most liberal state in the Union in the rights of slaves and free blacks. And one of the more interesting opinions, Benton v. Williams, Dallam 496. What happened was a slave got beaten by somebody not his master, and he sued for this. And the opinion said, "We cannot conclude that because they are not entitled to some particular privileges, meaning slaves, they are, while actually residing in our country, out of the pale of the protection of the law, and that injuries and aggressions may be wantonly committed on their persons and property, and that when they ask for a redress of such grievances, they are to be told that the courts of justice are closed to them." So the slave wound up collecting damages from this white person who beat him. There are many instances of slaves who sued for their freedom and won, either because they had been manumitted in Mississippi or somewhere and put back into slavery here. By the way, that Benton versus Williams opinion was written by Patrick Jack when he was on the Supreme Court. Does the name Pat Jack mean anything to you? This is the guy who, during the Anahuac disturbances of 1832, almost started the revolution when he was coming from Louisiana chasing runaway slaves. He's no friend of slavery. And these slaves had taken refuge in the fort at Anahuac under the Mexican commander. Almost started the revolution in 1832. And yet you had these card-carrying members of the slavocracy repeatedly hearing these cases involving slaves, and a lot of times they would win. You know, last night I was sitting here thinking, wouldn't it be funny, knowing that I'm supposed to speak for 30 minutes, if I actually got here and saw the little green light, yellow light, red light sitting on the... And here it is. One of the interesting things, I'm going to have to hurry along here. Now, you have an outline in your workbook, but since they decided that I'm going to be the lunchtime entertainment, I don't think anybody's expecting me to cover that whole outline in 30 minutes. I can't talk that, not even I can talk that fast. Very interesting case. There was a slave named Margaret Guess who sued to recover her freedom. She belonged to a guy named Adam Smith. He was a business partner of a fellow named Morgan, who was the not owner because she was free of Emily West, the Yellow Rose of Texas. Anyway, Margaret had been his companion, lover. They had a daughter together. He had given her freedom, although her manumission only had one witness, not the 5 that was required. And so when he died, Adam Smith's nephew sued to own her and the daughter. The daughter they had together, which meant that the nephew was suing to get ownership of his own cousin. That was Frank Lubbock, who later became governor. Well, she won. So there's, by the way, did you know that under which decision was it? Did I write it down? Calvin v. State, 25 Texas 789. If a slave was accused of a crime, the state had to provide him counsel. How long was it until that found its way into federal jurisprudence, that you have to give counsel to an accused? Well, hurrying right along, one of the hallmarks of Texas jurisprudence in this era was the court's willingness to dip a toe into what they call equity, to come to a just decision. And this was an object of some concern to them, and it was Abner Lipscomb who did this at one time, because there's not a lot of statutory law. They're having to make up a lot as they go. and somebody was saying earlier how much of the business that comes to the court now is statutory. It wasn't true back then. And so they would have to refer, how do we get to a just result? And it was Abner Lipscomb who said that, as it was said by Lord Redesdale, that the distinction between strict law and equity is never in any country a permanent distinction. Law and equity are in continual progression. A great part of what is now strict law was formerly considered as equity, and the equitable decisions of this age will unavoidably be ranked under the strict law of the next. So there was this acceptance by the court back then that law and equity, case law, precedents, and reaching justice operate in tandem. So when you reach an era like our own, in which the mantra is that you should only interpret the law, that was actually one of the weaknesses of the Mexican judicial system that brought about the revolution, was that the judges in Mexico could not do anything other than interpret the law. If only they'd had Fox News then. When we get to the Civil War, you see the Texas court also using its independence. We were the first case to hear it, the first state to hear it, and we almost overturned the Confederate draft law, which predated the Union draft law. And one of my favorite justices, James Hall Bell, our first Harvard man on the court, he was the dissenter, pointing out that under the Constitution, armies had been selected from the state militias. You couldn't just go out and nab people from their homes and farms and draft them into the army. He was very vocal about this. By the way, he had studied at Harvard under Mr. Justice Story. So when the majority opinion cited Story on the Constitution for the fact that you could, he said, he didn't say that, I was there. So I got to, by the way, another of his arguments was, we just seceded from the Union on the basis of states' rights. And now the Confederate government is going to step in with all this power and majesty and tell the states what they can do. That's not what we seceded for. So lucky me, I didn't wind up having to write a history of the law, but these fascinating, fascinating people on the court were really my stock in trade. When we get to the late 19th century, we hit what they call the consensus court. Reuben Reed Gaines, who was Chief Justice from 1894 to 1911, one of my favorite people, he, how should we say this, faultless judicial temperament, courteous, soft-spoken, just the most kind gentleman, sort of a Mr. Chips of the Supreme Court. Well, there was that time that he chased a waiter out of the Driscoll with a carving knife, but that was an exception. He and Thomas Jefferson Brown and Frank Williams for many years became the consensus court. They went 10 years, 11 years. I think there were 4 dissents and 3 concurring opinions or some such figure as that. And the way they would work was that Gaines would read the holding from down below. It was kind of a fast little mumble, and he would just kind of get through it like this. Well, T.J. Brown was hard of hearing, so Deputy Assistant Clerk Clamp would yell into his ear trumpet, kind of like Garrett Morris doing the news for the hard of hearing in the old Saturday Night Live, and in the holding below. And then Williams would have the pleading, and then they would make up their mind what to hear. By the way, the old Supreme Court room in the state capitol, the original benches there, put back together after it was expanded for 9, now it's back down to 3. When they hired Deputy Clerk Clamp, and by the way, his memoirs, a little typescript of memoirs, of his 52 years as a clerk on the court was a huge piece of source material for me. He noted that motto that is on the bench in the old Supreme Court, Sicut Patribus sit Deus Nobis, famous as the motto of the city of Boston. Many years it was translated as he was to our fathers, so may God be to us. Well, Clamp, who had actually taken Latin, said, no, sicut patribus sit Deus nobis. As our fathers did, God will do to us. Vastly different story there. Of course, Latin is wonderfully ambiguous, which I think is why the Romans, whenever they would put their big inscriptions on buildings, just used initials. SPQR, Senatus Populusque Rotum. That's not ambiguous. But you can't ever really be sure what the Latin is meaning, but I thought it was really interesting that we have that possibility, that it wasn't this blessing, it was really an admonition. Now, when we established the Republic, the rights of women, which we've been talking about somewhat up until now, were pretty well established. And it's interesting that it's on way late in the century, as we become more hidebound in our identity as an American state, that's when the assault on women's rights began. By the way, I understand that nobody has mentioned Seneca Falls yet. The big women's rights convention at Seneca Falls in 1848, Elizabeth Cady Stanton and all these people published this manifesto. Beg your pardon? Thank God for New York State. Finally, we've got marital property rights, community property. New York has finally liberated us from marriage slavery. This is in 1848. They knew very well that Texas had joined the Union 3 years before with community property already enshrined, but they didn't want to give that kind of credit to a slaveholding southern state. This is called a lie. Well, in fact, New York had debated a community property provision when they redid their Constitution in 1846 and turned it down. So it was really late in the 1800s when you had, and I was surprised when I walked in, somebody was quoting the case about the woman telling the tavern that they couldn't serve liquor to her husband or she would have their bond revoked. That was quite a big case in those days. There was another one of no spousal immunity when a fellow, what case was it? King v. Sassaman, when the husband, well, they got divorced, and the husband accused his wife of giving her a social disease. Actually, he gave it to her. So she sued him for slander, and he said, you can't sue me because of spousal immunity. You can't testify against me. Well, the Supreme Court stepped in once again. There's no statutory law here, so they had to dip a toe into equity to come to this just result, saying, well, we're going to carve out this exception in the spousal immunity provision that if you do this to your wife, no, that's not going to help you. 2 minutes and 29 seconds. When I was working on this book, it was one of the most fun things to discover these justices that I really came away with awe of. In fact, I interviewed former Chief Justice Pope a couple of times for this, and when I had no idea that this man, when he wrote that famous decision in Valmont Plantations, overturning Calvin Curitin's Model v. Boyd, which had been the law for 30 years. What happened in Spanish law, if you buy the land, you don't get the water. Well, Chief Justice Curitin, although he was very studious and very competent, he was an autodidact. And when he made a mistake, he could be very certain of his mistakes. And so he said in Model v. Boyd, well, we're a state, we've got common law, so we're just going to do this. This is what people have been depending on. Pope, when he's on the circuit, the appeals court in San Antonio, said, well, that's a Supreme Court decision and we can't overturn it, but that's just dicta. You don't have to follow dicta. And when his case got to the Supreme Court, it's one of two cases in the entire history of the Supreme Court that they just adopted an opinion in toto and said, yeah, can't argue with that. So they just adopted his opinion in Valmont Plantations. Huge respect for Pope. I mean, what a rock. I actually got to interview him a couple of times. And so I'll close with this. Associate Judge Justice James Hall Bell during the Civil War. Now, I bet you didn't know this, that before the Civil War, we had that referendum, do we really want to secede? And it passed like 46,000 to 14,000. Huge support for the Civil War, right? Well, Justice Bell was a Unionist, and he went home to Brazoria County to vote, and they gave him a ballot. And there was a big pink piece of cardboard that said, for secession. So he asked for a pen, and he struck out for, and he wrote in against. And the poll watcher said, Judge Bell, I'm really sorry to see you do that. You're going to regret it. Did you know that they suspended secret ballot when they voted on the secession issue? And even then, it didn't pass in the northern tier of counties. It didn't pass in Austin. Of course, even back then, we were the blueberry floating in the tomato soup. And there were even slave counties that also did not, one, it didn't pass at all in, and it was a very close issue in others. Okay, 4, 3, 2, 1. Buy this book. You will love this book. I'll be back there signing it. Besides, I've got bills to pay. Now, I know that there's a sort of story out there in the world abroad that history has become the province of academic liberals, and it's all about their take on the world, and real people who live in the real world don't really have anything to do with it. I don't buy that. I don't really care what your history is or what your politics are. I've got a red pen, I've got a blue pen. I will sign the book any way you want. So if not now, then certainly during your reception at 4:50. I thank you for your kind attention.